Thank you all for joining. Good afternoon. We will talk today about the formal EEO process. And this is an area of law that I've been practicing in for more than 30 plus years. It's an area that I've chosen to concentrate in because it's so important and also provides the opportunity to be so helpful to so many. So let's go ahead and get started. In this hour's time, I'm going to try to give you as much as possible about what you should know and what you can expect once you engage in this formal EEO process. All right, next slide. And what we know that you will learn today is when and how to file the formal complaint. We'll also talk about timelines for you to understand the importance of the timelines. We'll talk about the investigation phase of the formal complaint and also about that report of investigation that you will receive. The acronym you may hear me use over time may be ROI. And then we'll also next talk about how you should look at that report and then what you should do upon receiving that report. Next slide. What it tells me when you have a person who contacts me and they say, well, I am deciding on starting the formal process in an EEO case. So it tells me that ADR, mediation ADR, was not successful. And I want to take a moment and talk about that with you because for my purposes in doing this work, I always think and encourage clients, when it's feasible, to engage in the process of trying to resolve the case early on. It is important and valuable because the process you are about to engage in has a track that will take you from where you are informally and potentially can lead you all the way up to federal court. That takes a lot of time, it takes a lot of resources, and it requires you to invest a lot into your case. And to the extent that you are able to get an early resolution to your case, I believe that it is at least worth exploring. But if you're going into the formal stage, it means that the ADR process, the mediation of your case, a resolution was not reached. And so what you'll get is a notice of the right to file your formal complaint. And when you receive that notice, that should give you, I guess it would make you understand that you're at a critical point in your case. And that notice of right to file will have a deadline in it. And it will tell you that you actually have 15 days to file your formal complaint. Now, there are things that you should take a look at that will be very important in moving into that next stage. So the EEO counselor's report will be provided to you as you are receiving that notice of your right to file your formal complaint. The EEO counselor's report typically will have in it, some standard things that are required, but for the most part, it's going to tell the story of your conversation, your discussion with the counselor, and the complaints that you made to the counselor. That report should be reviewed very thoroughly. And the reason for that is because when you move to the formal stage, you are going to be taking over with you what you talked to the counselor about. But what's most important is that you can only take over with you what you talked to the counselor about. Now, there are some situations where you can argue things are like or related and you can expand and extend. And, we look at cases like that and sometimes those options are there. But the best practice would be to look at that report to make sure it contains everything you talked with the counselor about. Because that formal complaint form that you will receive will give you the 15 days to file that form. And let me pause here to say that that 15-day period is critical. Because if, in fact, you miss that 15-day period, for all intents and purposes, your case ends there. Now, there could be some extenuating circumstances where you may be able to show and therefore argue successfully that that time should be extended. But you really don't want to find yourself at a point of engaging in a fight to make your complaint or permit your complaint to move forward. There are circumstances where, for example, if you were misinformed or misled by someone within the agency, and you can establish this, that as to why you filed late, or there could be other circumstances such as you were incapacitated. And sometimes medical documentation may be able to be submitted to support a position like that. But for the most part, You want to make sure that you have that formal complaint completed and submitted where directed and as directed timely. That notification is giving you an opportunity to talk about and expand upon what you talked with the counselor about. Now, I find in some instances that some individuals, some employees will take the opportunity to sort of think a little more deeply, a little more completely about what has been going on in the workplace. And oftentimes you may find that in this area, when they're writing, they'll start to elaborate and in some instances even come into or give rather scenarios that were not what you discussed with the counselor. Now, this presents a problem because if you are adding things that were not part of the report, when the agency receives that formal complaint, your formal complaint, that complaint will be reviewed in comparison to what the counselor pointed out that you covered. And if it does not match, sometimes you'll find that the agency will send you a notification. It's called an acceptance letter, which we'll talk about in a little more detail later, telling you that your formal complaint has been accepted, but the following matters that you've listed are not going to go forward because they were not previously discussed with the EEO counselor. So having that discussion with the counselor about all of the matters that you want to move forward is just really critical. And it will help you if you actually create a list of those things you want to cover with the counselor and just kind of have it as a checklist so that you make sure that you are covering what you want to cover and that there is no question about what you've relayed to the EEO counselor. Now, once you actually have the information in, you're worried about something called exhaustion. If, for example, you just begin to add things into the formal complaint. That's because that complaint will be submitted to the agency, it will then be reviewed, and then you may get that letter identifying what's going forward and what may not move forward. The problem is that sometimes things will happen to you after you have filed your EEO complaint, meaning you've made EEO contact with the counselor. In between the time that you've met with the counselor, you've talked with the counselor, you may have things that have occurred. You may have a non-selection. You may receive a performance evaluation. You may get reassigned. However, those things are not things that will automatically join that EEO complaint that you began. So you have to make sure that you are taking steps to go back and exhaust those complaints, unless they are later, like I said earlier, deemed maybe like or related, and then they can participate. But the better course is to make sure that the EEO office knows about anything that you didn't cover with the EEO counselor so that it can participate in your case as you move forward. And so once you have your complaint completed, I want to draw your attention, if we can, and Pat, maybe we can share a sample complaint form that you may receive as a federal employee, showing you what it is that you need to complete. So you may likely receive something like this form here. This one is from Navy, of course, but it's pretty generic and similar to the forms that you'll receive. I want to draw the attention. Let's look at section 9, I believe it's 9C. Let's take a look at 9C on the form. And 9C, I believe it's saying that it wants you to identify what happened. And if you look at that, there's a small space there. But of course, you can attach additional papers if you need to. But there is where you're telling your story. And there is that is the area the agency is going to use to decide what claims you are seeking to advance. Now, you do have the opportunity to abandon some earlier claims. So they're going to look at this to see what is it you're trying to advance. And again, they're looking to see if you've added something. And so be very careful and be very explicit here as to what you're trying to claim. So that's 9C. If you look underneath of that in the section 9D just below, that area there is asking you to identify the bases. Now, when you see the EEO counselor for the first time in your informal complaint, you're going to tell that counselor what happened to you, and inevitably you're going to be asked to say, well, why? Why do you believe you were subjected to this? And what should come from you is, I think it's my race, my sex, my age, national origin, religion, disability, whatever you believe, but it typically will fall under Title VII to one of those categories under 9D. Now, here's the thing that I see a lot of. And, when people are dealing with things and they're trying to complain, they're asked to check those boxes and they pause for a moment and, they're not sure. They just know, something has happened to you. So what you begin to do is you check each box. You can say, I have my bases covered if I check everything. All right. And you can do that and your form will move forward. My recommendation and suggestion is not to do that. You also don't want to fail to check a box that's important. So what does all of that sound like? From the informal stage, which I always wonder why it's called informal, because to me, it is one of the most important steps that you take in the EEO process because it's foundational. What you are saying and what you are doing with the EEO counselor is the foundation of your case. You all have heard me say that when you get to the formal stage, you are relying on what you told the EEO counselor. So when you seek counsel in your formal case, yes, that is a great idea. It's wise, but you are going to be limited to those things that you covered. And I can't tell you, there are a number of times where I've had interviews, I've done consults, and people will tell me their story and about their case. And when I hear what they're telling me that they would like to file on, and I read what's in that acceptance letter, it's different and it's not the same. And therefore, what was said at the informal stage will bind you and will keep your case locked to that unless you have the ability to amend, and we'll talk about that later. But these boxes become important for another reason. And, I've, like I said, been doing this for a while. I've actually operated as a federal investigator investigating these EEO cases many years ago. And what I found very interesting is I would sometimes receive a case for investigation. And when I look it over and then talk to the complainant, there were things that were done wrong and there were problems that occurred, but they've mistitled or misidentified the bases. And one case I think of in particular was at the Philadelphia Naval Shipyard, where a woman who worked in this predominantly male division down at the shipyard felt that she was being overlooked for promotions. And she had endured and then decided, I have to file this case. And she did. And when she filed the case, she stated that she felt that she was discriminated against based on her race, and here's why. And she told her story. And she had three individuals she used as comparators. And, they were all males, and they were of a different race than she. And that's what she stood by. But as I investigated the case, as I asked her for information, I'm not there to give her legal advice or guidance. And it became very clear to me that what she really was experiencing is what could have been determined to be a history of females not being provided with certain opportunities within that shipyard. But her case went forward as a race case, and inevitably, she was unable to establish that race was the reason for her non-selection. Would she have been able to establish gender? Likely. And back then, as we will talk about later, when you had a report of investigation presented, you would actually make a finding as to whether or not there was discrimination. So these boxes, I wanted to show you that example, give you that example, because these boxes are very important. When you check each one of these, or whichever ones you decide to check, you have the requirement, you will have the responsibility of bringing forth the evidence that shows that it was race, or that it was sex, or that it was religion or disability. That's your burden. And you may have a wonderful case, meaning a great case with facts that will be able to show that you were treated unfairly, but you checked the wrong box. And so think about that. Think about that as you're doing it, and realize that at the end of the day, if your case does not settle, which of these boxes you have chosen to check becomes critically important. Because if you retain an attorney and this case is brought forward and is put through the litigation process. At the end of the day, let's say you are successful, but by the time you get to the end, the claim for religion, discrimination based on religion, has fallen away because you were unable to develop that evidence, or the claim or the basis of age falls away, and then when all the smoke clears, you still have your gender claim and you're happy, except when you are successful and your attorney puts in that petition for the fees and costs that you've been asked to pay. The judge inevitably will likely say, well, you did win, but this case has been fought with 5 or 6 bases and you only won on one. So what we're going to do is but we're going to reduce out all of those fees where you and your counsel spent time on the religion claim, on the age claim, or the disability claim. So it may not seem that critical right now and you check all the boxes, but later on, that could weigh very heavily against you. So think about that when you're checking the boxes as to where you're going to go. Okay, we can move that form. Thank you for letting me share that with you. And what we're going to do, yes, now is take a look. Yes.
May I ask a quick question? Is that appropriate, or would you prefer it in chat?
So Pat, tell me how you want us to do this.
We'd like to keep attendee microphones muted. If you could submit your question during the chat, we'll pass that over to Donna to review after she gets through the presentation.
Okay, thank you for that. All right, so, from what we've just discussed thus far, there's some things for you to consider. And that is, of course, retaining counsel and basically making sure that you have all of these different corners battened down. Because as you can see, from the informal moving into the formal, there are a number of things that you have to look back at, and there are a number of things you have to be conscious of as you move forward. So making sure that all of those things are covered, so that when you do get an attorney involved, it's not where you're being told, as I have to sometimes tell people, you didn't make a claim about that non-selection. You didn't make a claim about that particular performance eval. And, you didn't go back and exhaust on this point. So just keep all of that in mind. Things are moving very quickly. We'll talk next about the acceptance letter, all right? And what we'll talk about is to show you that next important step once you get it. Let's go to the next slide. So we've talked about that it has to be filed within 15 days of receiving that notice. And that sounds pretty simple. I mean, we all can count, we can do the 15 days, but that's not where the problem comes in. And yes, there are sometimes some great concerns about this. And that is, I actually had a couple reach out to me. The husband had filed an EEO complaint. He had received the notice of his right to file. He had the 15-day indication there, and he wanted a consultation. So I said, sure, let's set that up. And he asked about coming in the next day, which I said was fine. You can come in the next day. And so we scheduled it for the next day. And I said, but wait, when did you get your notice of the right to file your formal complaint? And he said, oh, I got it yesterday. And I was like, okay, fine. Let's meet tomorrow and we'll be fine. Bring that with you. We had the scheduled meeting. He appeared. He gave me the letter. And the first thing that I noticed is that the letter had a date that was several days earlier, 5-7 days or more earlier. And I said, what happened there? And he said, what do you mean? I said, you just told me you got this yesterday. He says, oh, my wife and I, we were on vacation. We did a 10-day cruise, and we got back, got things situated, and noticed that we had some notices at the post office. We went to retrieve, and we had this green card showing that I had the right to file. And so I quickly asked him, to show me the green card. And of course, if you took the date that they delivered that or attempted to deliver it, and you look at where he was, we were literally meeting on his 15th day. And so I was able to file the case for them and move the matter forward, but that could have been devastating and really catastrophic for him, because in his mind, he says, I just got this because I can prove to you that I just received it from the post office. That's not how the timeline is counted. And so be very careful there when you're dealing with that 15 days. Know when the clock starts, and it starts from when it was presented to you. So if it's sent by email, it's the day that it arrived in your email box, not the day that you reviewed it in the email box. All right. And the next bullet there talks about what we mentioned earlier about amending. Now, you can amend because, like I said, sometimes things will happen after you file the informal as you are moving forward through the process. And yes, I have occasions where I have actually amended EEO complaints for my clients a number of times throughout the process, unfortunately, because other things will occur. So if you're making an amendment, there are steps that you should take, but you do have the ability to do that. And at this point, you also want to talk about the fact of that acknowledgement letter. Let's look at the last bullet. It says here, the agency is going to send you a letter acknowledging receipt of your complaint. And this is important because when you believe you submitted it and when they say they got it, and that has to be reconciled right there. Because if you do the math and it's received after that 15-day period, it is then that you have to start planning and presenting why your case and your claim should move forward nonetheless. And hopefully you would have some of those complaints or stories that you can share, such as the fact that you were incapacitated or someone told you wrong or what have you. And yes, it can happen, but it's very rare. So just make sure you're watching for those timelines. Let's go to the next slide. So we're going to talk about the investigation phase of your complaint, but that acceptance letter needs to be emphasized here again. The acceptance letter is going to say to you, we've received your complaint, and you'll get an acknowledgement letter first saying we've received it, it's going to be processed, you'll hear from us. And at that point, you're in a holding pattern. You're waiting. They've told you that they got it on May 5th, and they're going to process it, and you'll hear from them. But then you get that letter, which is called the acceptance letter. But it also can say acceptance and dismissal of claims, which means some of your claims may be accepted and some of them could be dismissed. And you have to read that letter carefully. As it relates to the issues accepted, pay particular attention to them. Read how it has been identified as either 1, 2, 3, 4, or A, B, C, D. But what you want to look for is what they're saying the claim is, okay? Is it saying that you have been discriminated against based on, and you're checking the bases, your race, your sex, your age, and subjected to a hostile work environment? Or is it not identifying one of your bases? So that's the first place you're looking. Does it have all of your bases? And sometimes people say, well, I was in a hostile work environment, but they never said that. They gave facts and circumstances that would, they believe, cause anyone to see they're in a hostile work environment. But you say the words. You say, I was in a hostile work environment. And if it's not there, that's when you reach back and say, no, it was clear that I was trying to convey that. Let's fix this right here. The next thing you look at is what's been accepted. And when you read what they're saying is going forward, read it literally for what it's saying, because if that's not what you're trying to convey, that's where you need to make a correction. You need to make sure it accurately reflects. Are you complaining that you were non-selected for a position? And I get this a lot, where the person will read that and they'll move past it and allow that claim to go forward. But then when I meet with them, what I will inevitably learn is that they never applied for a position. And, ladies and gentlemen, in a non-selection case where you have failed to apply for the position, that will be fatal to your claim. Okay? And so when I'm talking to this individual and I'm learning about the case, what I come to know is this. There was a position. There was supposed to be a notification about that so people could apply. And what happened is this particular supervisor picked his or her favorite person, placed that person in the position, and then announced it to everyone. And so the issue really is that you should have been one of those individuals selected for that position and you were not. But that's not a non-selection in the what we call technical sense of what that normally conveys. So you don't want to say that you were non-selected for a position. You want to say that you failed to be considered for placement into the position. I know it sounds very, okay, that sounds a lot like the same thing, but trust me, it isn't. I've had later on down the road administrative judges, when I've gotten involved in cases like that, start out the first introductory meeting by saying, Ms. Rucker, what's going on here? Am I clear that your client never applied for this job? How is this a non-selection case? And I hope, and I have to be prepared to be able to say, well, Your Honor, if you look at page 5 of the investigative report, my client clearly was trying to articulate the circumstances, and the way the agency picked up that claim made it identify as a non-selection, but it's clear what she was trying to say. And I've been successful in allowing the claim to continue, but it really does matter what you say and how clear you are about what you're trying to report. So make sure that that acceptance letter gets the attention that it needs. It will also tell you the number of days that you have to correct what is in there. Pay strict attention to that, because what happens is if you do nothing, then what's there is what will go forward. And later on, once again, when people come to me and they're telling me about what they want to fight about or file their claims about, it's not what's been accepted. And an investigator, which is what we're about to talk about, is only going to interview you regarding the discrimination complaints that were accepted for investigation. They have no authority and no ability to talk about these other matters. Doesn't prevent you, when you're giving your affidavit, to cover what you think may be relevant. If you believe that something is being done wrongly, you don't want to leave it out. But the investigator is not going to focus on issues and claims that have not been accepted for investigation. All right. And so when an investigator comes out, the investigator will interview you. And when you're going through the interview process, that is now done, virtually with a phone call. Typically, it's a phone call that's being recorded while the investigator takes down, and it may be transcribing what you're saying in response to questions, or you can have those questions sent to you. Those are called interrogatories, where you will be asked specific things and given an opportunity to give your responses in writing. And the investigator inevitably will ask you about witnesses and people you believe may be helpful to establishing or showing the discrimination that you've been subjected to. Most important here is to understand that the investigator does not have to interview every witness you identify. You should tell the investigator about people. You should tell the investigator what those individuals may be able to offer. And ultimately, though, the investigator would basically say to you that I'm only going to talk to Peter and to John, and I'm not talking to Mary. At this point, again, it's important for you to have the record reflect that you've proffered these witnesses, you've presented them, and this is what they were going to testify about. And so that later on, you have some recourse about not having those witnesses interviewed and their evidence or statements considered. But the investigator will conduct that investigation in the manner that he or she determines. There are also instances where you may want to give certain documentation. And I get this a lot, where people say, well, I sent over, 30 pages of documents to the investigator. And when I received the report of investigation, only 5 pieces of those documents made it in. Well, that's important for you to then note somewhere that this is a request. So typically, the way I do that is when my client is sending in information, I will indicate to the investigator, here are the documents we would like for you to include in the report of investigation. And will you please make this request a part of your record as well? And that way you can actually have a record, if all of the information doesn't make it in, that this is what you tried. Because, again, looking forward to maybe an administrative hearing before a judge, administrative hearing with an administrative judge, sometimes when you're trying to get those witnesses involved in the case or those documents considered, the judge will ask, well, are these documents and this information that you tried to give to the investigator? And then at this point, you actually can show the fact that you did try to give the specific documentation. And so for that instance, just make sure that you're able to show what you tried to give the investigator as you're trying to do it. Now you'll see the next bullet where it says the investigator does not decide merits. And so that is true. You may have heard me say earlier that that was something that used to happen. It was. But now the investigative report is really a gathering of documents and information for the record to be developed in an effort for you to show that you were a victim of discrimination or retaliation. And at the end of the day, some people, when they get that report of investigation, which, you know, can be very voluminous. It could be, you know, I've had reports that are 3 and 4 volumes based on information. But what there isn't as a part of it is anything that indicates the fact that there is or there isn't evidence of discrimination. And sometimes that's disappointing for people because they're like, well, you know, what was this all about? But there isn't going to be a particular decision on the merits of your case. And that document, the report of investigations, starts the process of you making decisions about what you want to do next. So the whole idea of it is for you, when you come to the process, typically you feel you've been discriminated against, that there are things that happen to you, and you don't have information. So this actual report of investigation can also serve as evidence or information for you where, okay, you feel like you were discriminated against because you weren't given the opportunity to take training, but you know that, you know, Mary and John, they were able to take training. And then when you get this report of investigation, you see that the training that they received either was unrelated to what it is you were trying to get, or was mandatory training within the concentration of the work that they do, or some other thing that allows the employer to offer what we say is a legitimate, non-discriminatory reason for why they received training and you didn't. So you have the choice of saying, okay, I no longer want to complain about not getting training, but that doesn't resolve it as to the rest of these. So the report of investigation is to serve as well as a manner and a way of providing you with information so that you can decide what you'd like to do next. Agency has 180 days from the date that you file your report, your actual formal complaint, not the contact, to issue that ROI. And so during the course of the matter, you may find that the dates and time stretches out. For whatever reason, you may become sick, somebody else may be unavailable, and the agency oftentimes will ask for you to give them an extension. And if you agree to that, then that's going to extend that timeline of the 180 days. But after that time passes, it entitles you and gives you specific rights to move your matter forward. You don't just have to wait and sit, as you are required to go through this process to exhaust. If they reach that 180-day period and things are not done, it gives you rights give you the right to move your matter forward, and no one challenges as to whether or not you have in fact exhausted your case. Next slide. All right, so now we're talking about the employee then getting this ROI, and now you have to make some choices. So, you know, the way I like to say it is you can do nothing, and that could be because you've now had you've received answers to questions you've been trying to get answered. You can actually say that I am going to file a case with requesting a hearing, and your notification will tell you that you have 30 days to do that from the point of receiving the ROI. Again, that date is important. So you want to make sure you're marking your calendar and counting again from the proper period from when you receive that report of investigation. And you have a choice of asking for what's called a final agency decision. That's that top bullet there, okay? And the final agency decision is essentially your request to have your ROI analyzed. and a legal opinion issued relating to whether or not from that record it appears to be discrimination exists. And that final agency decision, as we refer to it as a FAD, is given to you if you do nothing. So if those 30 days will pass, if they pass, 30 days pass without you doing anything, you're going to get a final agency decision. And that decision is going to give you, again, appeal rights. So it doesn't end with that, but it does eliminate the ability to go to that, for that hearing stage where you have your case addressed before an administrative judge. So the final agency decision leads you to another appeal level, to the Office of Federal Operations, or you can go into federal court. But the hearing request, that the 30-day period there is what gives you the chance to go to that go before that administrative judge. And again, even there, if you're not successful or satisfied, you do have further appeal rights, which ultimately can lead you, as you heard me say at the beginning, into federal court. And as you can see, by the time you get to federal court, you have a well-developed record, and that record is going to be what follows you. So as you've heard me say throughout, it becomes very important to make sure that the record is being developed accurately and that it is being developed completely with the relevant information pertaining to the claim that you want to bring. Now, if you take the EEOC hearing process, that's the process before the administrative judge. That's indicated in the second divot there, the second bullet, where it's talking about what it involves. So an EEOC hearing is essentially a hearing with an administrative judge who is appointed. And this is the Equal Employment Opportunity Commission, which is the federal agency. There are administrative judges on staff there, and their job and their goal will be to provide you with a hearing regarding the facts and circumstances. And the interesting thing about selecting the EEOC hearing, and I talk with this about clients often, is the way your case develops from there. And if you, for example, were to take the final agency decision, your ROI is going to be reviewed from its four corners. So someone will be reviewing that to make that legal analysis, give that legal analysis, and reach that decision as to whether discrimination appears to have occurred. With an EEOC hearing, you're not limited to what's in that report of investigation. You are able, through the litigation process that's similar to what happens in federal court, to embellish that record, to add to it, to expand it in ways to address issues that you've now come to know needs to be further developed. It affords you the opportunity to get discovery. So, for example, you have the ability to ask for interrogatories. Those are questions you can serve the agency. You can ask for the request for the production of documents. You can ask the agency to make certain admissions. And this is part of the litigation process and in the discovery process. Judges will decide how much discovery and to what extent you get to have discovery, but typically it's allowed. But as you can see, it allows you to get more information. That usually comes up because when you read that report of investigation, sometimes you hear things from management officials, we call them responsible management official, RMOs, and you receive information that you wouldn't have thought about presenting at the investigative stage. But now that they've said that, you're like, oh, wait, I have evidence of that. I have witnesses for that. So you have the opportunity to add information based on what management officials or other witnesses may have offered during the investigation. The agency will likely have their attorney representing them in this process, and they will then be afforded the opportunity to do the same in this process. They can serve you with interrogatories, requests for documents, admissions. And that's the litigation process in terms of what we call paper discovery. And if you want to expand it, you can also conduct depositions. You can call for your supervisor to be brought forward, placed under oath before a court reporter, and have questions asked that are relevant and that you believe will help develop the record in your case to show that there was discrimination. This process also will allow the agency to move forward to try to move to dismiss the case. And inevitably, the agency files what's called a motion for summary judgment. And that motion for summary judgment is basically saying, okay, the complainant in this case has been afforded the full opportunity to develop a record. We have the report of investigation. We have the additional written discovery that you permitted, Your Honor, and we have potentially deposition testimony. And when you take all of it together, the complainant has failed to show that they failed to show that they were subjected to discrimination. Let me pause here to say this. Everything that you do when you start your EEO case, you must always be trying to show that you were discriminated against or retaliated against. Every piece of evidence that you gather, every witness that you bring forward, the goal and the mission is to show that that helps show you were discriminated against or retaliated against. I have clients who come with stacks of information and evidence to show what happened to them. And that's important. But after you give me what happened to you, and it has to be thorough, I then put that aside and say, put before me now what you have that shows it's because of your gender, because of your race, because of your disability. And you have to put that evidence forward just as well, because you can prove over here all of these things were done to you. But in a Title VII case such as this, you also must prove that it was done for some impermissible or illegal reason. Those are the boxes that you've checked. And you will be held accountable for showing the evidence for the boxes you checked. So if you check gender, here's what happened to you, but where is the evidence that it was because you are a male or you're a female? Because that information is just as critical, and without it, the claim can't progress. And if you do try to progress the claim without that, that's where that motion for summary judgment will likely be granted. And people will say to me, well, Ms. Rucker, I've been able to show that I've lived through this horrible period at work. I've been overlooked. I've been disregarded. And then inevitably, I go back to the fact of, but you had to show that it was for whatever the box was that you checked. So if it was for gender, you have to show that you didn't get selected because of your gender. Not simply that you didn't get selected and you were the better qualified person. And that's sometimes hard to connect. But from the beginning, that is what you are developing. And you're not just developing that, but you're developing the evidence to show the bases and that you were harmed. And so we're getting into a lot of other things. But these cases are very detailed, as you can see, very fact intensive. And it's very important that along the way, you are gathering everything that you need in order to be able to be successful. So the judge actually, if you get a hearing, and potentially statistics aren't that great for cases surviving, and maybe for the reasons we described, it's not being developed in the categories required as needed. But if you get a hearing, the administrative judge conducts that hearing similar to what you see for trials. And that means you present your evidence, you present your witnesses, you do cross-examination, direct examination, and then ultimately the judge will make a decision as to whether or not you have any claims. And if the agency, once the judge issues the decision, the agency has 40 days to implement that decision. And also then you'll get whatever notification you get will be to inform you of your appeal rights, like I said, which will take you then on to federal court. We can go to the next slide. And we've talked about the discovery. We've talked about what you get. The judge gives you timelines. And like I said, you never know. It depends on the judge. Depending on how thorough your report of investigation is, sometimes the judges will not even allow you to have additional discovery. Some judges may say, well, I think the report of investigation is pretty good here. Tell me what else you need. And you literally have to be able to present what you think needs to be further explored for the judge to give you the opportunity. Again, having an attorney in this process, and from the very beginning, I always say, is so critical to be able to show and to be able to develop the case that you need. When the judges get involved, typically from the initial meeting with the judge, you have 20 days to initiate that discovery, typically. Read the order, read the order. It will tell you how much time you have. The order is very important to your case because it gives you the specific timelines for that particular administrative judge, and it also will let you know what is expected of you by this judge. Next slide. Now, we talked about the motions and the judge acknowledging and, getting the discovery done. We talked about depositions, so we can move to the next slide. When you have the appeal of the matter, what we can talk about on that is you have certain deadlines that you'll get. Again, very important deadlines. You heard me mention about taking that final agency decision if you're not satisfied and moving it forward to the Office of Federal Operations. We call it OFO. And you have to do that within 30 days of getting the decision from the agency. Emphasizing again, make sure you're calendaring the dates and times right. Then your brief is going to be due within 30 days of when you file your notice of appeal. And then again, OFO reviews all of the materials and issues in the case to make its decision. But that appellate process, like I said, can be somewhat long and drawn out. And one of the things that can sometimes happen is that people who are relevant with good information and knowledge about your case could retire, otherwise move on. And once they're out of the federal government system, it's hard to bring them back unless they're willing to come back. And you always carry the burden. So you always have to think about what's important in terms of where my case is going. Next slide, please. Now, you also can opt out of the EEO process and bring your case to federal court. And that is something that I had a practice of doing routinely. And it was for many reasons, but one of the primary reasons is that if you have a case where individuals are about to retire, the evidence may somehow or another be lessened with witnesses or other people leaving, you might want to try and get that into federal court as soon as possible. And you also are moving it away from the agency. When you go into federal court, you actually have the assistant, the U.S. Attorney's Office represents the agency in federal court. So the agency's attorney may be involved in terms of updating, but it's the U.S. Attorney's Office now who's involved. You have the judges who sit on that bench in the federal court who's now reviewing the case. For some people, that has value. Moving it from outside of the agency, getting it before individuals, getting that fresh look, that fresh view. 90 days after you get the decision, then you're filing this in federal court. And it gets a little complicated, again, having a lawyer interpret what days applies to you. As you can see, the 90 days that you have from the FAD and the OFO appeal, if you haven't filed, rather, your OFO appeal. And then 180 days from the time that you did file the appeal if you haven't yet received a decision. And so within the 90 days of getting that, you must note your appeal to the federal court. Next slide. And I want to make sure that I leave some time for questioning. So I think if the question is posed, when should you engage an attorney in the process? I think mistakes can happen from the time that you begin, from making that initial contact with the EEO counselor to what you do with the formal complaint. So I think it's best to consult an attorney to make sure that all your points are getting across, that you're meeting the timetables, and that you're doing all that you need to do to present the best case possible for what is happening to you. And oftentimes, having the attorney can also help you when you attempt settlement. And that is something I always think it's a good idea to explore very early in the process. Next slide. So Tully Rinckey provides these services. We do this, we do it well. We've been doing it for a number of years with great success with a number of cases and matters. I know that I have had, these cases once they've even reached into federal court. You may have even the federal court judges not really see it the way you think. After discovery, that summary judgment motion goes in and the judge grants it, case dismissed. I've appealed those cases. And I have successfully overturned 3 separate federal court judges on appeal. And the cases involved a race case, one involved an age case, and the other involved a disability case. So when you have the evidence and when you have the core information needed, it positions you best. So you get assistance with writing, your informal and your formal complaints. You're making that timely contact with the counselor. You're getting that representation, explaining at mediation why your case is one that should settle. And you're getting that representation even when you're before the administrative judge and, of course, before the judge in federal court. And, you know, depending on where the clients are located, we have offices in many different jurisdictions, and we can assist you and even associate with other counsel in states where we're not necessarily admitted, but can represent and continue representation of a case through what's called pro hoc vice. And so encourage you to take a look at getting counsel involved quickly. Encourage you to take a look at Tully Rinckey. Next page. Just keep in mind and take a snapshot of this when you're making your case. This is the important part which helps you begin to develop the case. And make sure that when you're making that contact with the EEO counselor, you have proof of that, because I do get a number of cases where individuals are not just actually able to show that they made contact timely. And so I've actually had cases where that had to be challenged. And so next slide. We know this, but we should say it out loud. Discrimination should never be accepted or tolerated. You should consult an attorney before you start filing any claim, and make sure that you get your timelines right. Mark calendar and remember your deadlines. And it's a battle. It's a long battle. And sometimes offloading that to an attorney who can carry that for you, it's what we do all the time. It's what we do each day. May be the best thing for you to allow this matter to go forward. And at this juncture, I'm happy to take questions. I see, Pat, we have a number of questions here. And first question that I see here is, at what point can you claim retaliation for filing an EEO complaint? And so for me, this is a very good question, because as you heard me say, when you start the EEO process, sometimes right after you engage in the process, things may start to happen. So when you first file your complaint, let's say it's for non-selection, okay? And that is your first time engaging in the EEO process. At that point, you now have engaged in the EEO process. So let's say suddenly you now are denied the ability to go for training or to attend a conference that you normally were allowed to attend. You may believe that that's retaliation. So your EEO activity now becomes that initial contact that you made with the EEO counselor. And the retaliation is not the first thing you filed for non-selection, but it is the denial of the training opportunity or the other things that you haven't gotten. So you have to set that up. But that's how you can do it. For a reprisal claim, you have to have prior EEO activity, and then something happens to you. So that's what you're looking at when you're trying to claim retaliation. You may not have it when you first file, but once you engage in the process, arguably whatever you encounter later can be tagged and argued to be retaliation. I see in another case, another question here says that I've received the final order from the MSPB for a non-jurisdictional decision. My applicable letter states that I have 30 days to file a complaint with the EEOC. The incident occurred during 2019, and I performed all due diligence related to my initial complaint and had an EEO counselor with the agency. Owed to the foregoing, does the 15-day deadline apply? So to this individual, this seems to be very fact specific to your case. I believe I understand your question, but I don't want to mislead you. Best that I can tell you here is take a look at what the letter and notification says that you received. You can have matters that have started a while ago, but just now may be receiving notifications about how to take your matter to the next step. That's going to guide you. That's going to direct you. So make sure that you follow that. Another question says, regarding a basis for filing the right EEO complaint, race, sex, etc., what if you really don't know the motive and what's happening to you is you seem to be more general labor law situation where you are blocked from training and career? So let me just say that when you are dealing with where you need to go for a complaint, this is a very good question because it allows me to say something important, which is everything that you encounter will not be EEO. And if you pick, I always do it this way, you're picking a door to walk through to lodge your complaint. You can literally walk through the EEO door with a complaint, a valid complaint that should get you the relief you wanted, but you walk through the EEO door. So in the EEO arena, they're going to ask you what happened and prove that it was based on your race, your sex, your age, national origin, religion, handicap, or that it was reprisal. And maybe you can't. But you can take that same complaint if you have the ability, for example, to file a grievance and just show through your collective bargaining agreement that you were entitled to something, you didn't get it, and the collective bargaining agreement has therefore been violated. No one asks you about your race, sex, age. So you don't always pick the EEO door, because that door requires you to prove a lot. It may be an Office of Special Counsel issue. It may be an IG complaint. So you have doors to walk through. So that's the best way I can answer that, is every complaint isn't going to be that. Consult with an attorney, find out where your complaint needs to be lodged, and then move it forward in that arena. And the next question says, my case was accepted as a mixed case. How does that change my formal complaint? So I'm not sure what the question is, but a mixed case is basically saying there are things that can process through EEO, others that have to go to MSPB. So that is going to be how your case proceeds according to that process. The next one says, does the 15 days include weekends? Yes, it absolutely does. These are calendar days. These are calendar days, so it will include that. The next says that I was awarded a position with the VA. The letter said I had to serve a 1-year probationary period. I alerted them that I was already established tender with the government from a previous 6-year employment, 4-year military background. They told me that there was no room for negotiation. They sent me the 315-802, and for their reason for not negotiating, they said I didn't qualify for no probation. Well, I didn't qualify for a no probation job because of this order. I didn't agree, sent them a few different orders, went back forth. They rescinded the offer. I went through the background investigation. So it looks like this person, whoever sent this, needs a consultation, because this has a lot of weaves and turns. But there's no straight answer to this, but there are things that can be discussed and suggested as to how to proceed with these circumstances. The next one said, the FAD, does anything need to happen on this in a timely way related to the hearing, i.e., do you need to request a FAD before hearing, or does it happen after the hearing? Well, if you're asking for a FAD, you're not getting a hearing. You're getting a written determination on the contents of the report of investigation. And so if you are interested in a hearing, then you must select and send in your request for a hearing within the 30 days from when you receive the ROI. Otherwise, you are not getting a hearing, and your next opportunity for court down the road will be in federal court. So that answers that question. Next question says, what happens if retaliation happens after the 15 days have passed? So I believe that this is a 15-day period for filing your actual formal complaint. Anything that happens when you make that initial contact is gauged by what we call the 45-day period. So if this new thing has just occurred, then it would be arguably timely for you to make that complaint to the EEO counselor, have that processing, and I have seen agencies that will allow that claim to catch up with your current claim that's moving forward in the formal complaint, especially when you have not yet had an investigator assigned to the case. So that's the way that you can answer that. You indicate that in some cases, it is hard to show that gender is a claim. If you check gender for lack of understanding of what else it could be, can you change that now and say retaliation? And I'm not sure of the motive. Well, if you checked gender and you later believe that it's retaliation, the basis for your claims are locked in as you move forward. I have seen, and I myself have argued for additional bases based on the evidence in the case, even if that box was not originally checked. And what that means is sometimes you are looking for within the actual affidavit and testimony and statements offered where the client is clearly saying that they believe it's retaliatory, even if they didn't say it definitively, presents an opportunity to argue that the case should also proceed as retaliation. And next one indicates that my EEO case has me wondering if I shouldn't get another job. I moved to another job outside of this government position. Do I still have a good case, or do I need to stay in the agency to maintain? You don't have to continue in your position once you've initiated an EEO complaint. That complaint will process whether you retire or whether you choose to move on. That case will continue to process unless you stop it. I often try to say, once you file, the train has left the station. It's going to make various stops along the way, and the only way that it stops completely is when it gets to that end in federal court, where you get a decision from a judge or jury, or if you stop it yourself through settling. And the next one says, how successful are hostile work environment cases? Those are case by case. Hostile work environment claims have a standard. They need to be proven. You have to show that what you've been contending with is either severe or pervasive, and that gets analyzed under the current case law for what shows that. So it depends on a case-by-case basis. What if you filed a formal complaint, it was dismissed, and the agency is retaliating because of it? Well, once you've engaged in EEO activity, then you can allege that other things you begin to experience will actually are occurring, because those things are occurring because of that prior case. And so you always want to be mindful of getting in and getting back in with an EEO counselor within 45 days of when you knew or you should have known that you are being retaliated against. So retaliation versus reprisal. It's just a term of art in terms of what you're using. Retaliation, reprisal. You're basically saying that whatever you are experiencing is the result of your engagement in prior EEO activity. That's what you're saying, and that's what you would need to prove. For constructive discharge termination, it's always going to be an objective standard. In other words, if you're saying that you were constructively removed from a position, it's very hard to prove, but the objective test is what's going to control. You want to establish and set up facts and circumstances where once you finish telling your story, anyone in the room, anyone you meet randomly would say, oh my goodness, how did you continue to stay there? That was a horrific environment. That's typically the test that you're going to have. Color versus race, it's simply, in some instances, people may feel they're being treated differently because their skin is lighter, their skin's darker, or their skin complexion in general is what's going on as to why things are happening differently. Always it's going to come down to what you're going to offer as evidence of why you think it is, and that's going to rely on what you can put forward that you heard or you experienced to make you think the color of your skin was actually a factor in what it is you've experienced. Can I get a consultation with you about my case and my case with the VA? Yes, the answer is yes. That's exactly what we do. So happy to have a consultation with you about the situation that you may be experiencing. Happy to talk with you about it. I think I caught everything, Pat, that you have in here, and I'll turn it back over to you. It's certainly a pleasure to talk about this, and it's very important stuff. And by the time you're thinking about this, it's really emotional. Allow us to assist you through that process. It's what we do, and it would be our pleasure to work with you.
All right. Thank you, everyone, for joining. Have a great day.